Welcome to Corporate Law Lab, hosted by the Corporate Law Center at the University of Cincinnati College of Law. I'm your host, Neil Taylor, Director of the Corporate Law Center. Today, I'm joined by one of my colleagues, Associate Professor Kate Jackson. Kate has had anything but a conventional career path, from West Point to corporate law to academia. In this episode, we discuss career transitions, fiduciary duties, and the evolving landscape of corporate law. But first, here's a powerful thought from Kate on why career changes, no matter how daunting they may seem, can be sometimes exactly what you need.
Whatever organization or industry, whatever you're in right now, it's going to feel like you are some kind of failure or some kind of traitor if you choose to leave. And what I learned, I left West Point and I felt guilty. Like maybe I wasn't hard enough, or maybe I wasn't strong enough, or maybe I was, too liberal or too female, or I just couldn't cut it for whatever reason. That's everywhere. You're always going to feel like you're betraying your tribe in some way. So the end of the day, it's so contrived, but do what makes you happy. Do what gets your juices flowing.
Let's dive in. Welcome to the podcast, Dr. Professor Kate Jackson.
Oh, thank you so much for having me. I used to think I should be called Dr. J after I finished my dissertation. But, on further reflection, I'm a 5 foot tall, overweight white woman and definitely not a basketball player for the 76ers. So, yeah.
You haven't done the windmill dunk in a while?
No. Not since I was a toddler and my dad did it with my body as the ball, I guess. Right.
So, like a lot of our guests, and I think if there's a theme to the podcast, it's that there aren't very many straight lines. I think you are our lucky 13th guest. And I think of all of those people, I think it was only Beth Naylor that took a job in a law firm that she's still at 40 years later. Pretty much everyone else has done a number of things. Mm-hmm. You, in fact, I think I saw back in your CV the U.S. Military Academy is way back there somewhere.
Yep.
So my father desperately wanted me to go to the Naval Academy mostly because it would be free.
Yes, exactly. Same here. My mother came back from the dentist one day when I was 16. It's like, my dentist went to dental school for free because he went to the Coast Guard Academy. That's where you're going. And I was like, all right, fine. So I found myself applying at 16 years old, with all the wisdom I had, applying to the service academies. And my Navy was my first choice back then, but I needed a medical waiver, and they wouldn't give it to me. But I guess West Point slums it, so they let me in. So, yeah, I spent 2 years there.
So why did you switch to Penn? Because...
Okay, so the politics back then were a little different. Like, Clinton was president. As a background, my family is pretty left-leaning. Their politics are very progressive, very democratic. My dad was in Berkeley in the late 60s protesting Vietnam. So he was like, what's happening? Okay, but all right, Clinton's president. The worst case scenario, I'm going to Africa to help intervene in terrible civil wars. So it felt, or Kosovo or something like that. So the politics were different. And by the way, it was free. And also, by the way, it was an excellent education. And honestly, the process of applying is so long and so intensive. Once you finally get in, it feels really stupid to say no. You need the physical exam, you need to get the recommendations from some kind of Congress critter somewhere. And the physical exam you got to pass. I actually joined a cross-country team to be able to pass a physical. I was all in on this. So I went. And I spent 2 years there. And, you discover, I guess I should have thought about this beforehand. You discover that it's like living in a teenage boy's locker room. And the public service aspect of it didn't seem as robust as I would have liked, I guess. And there was a strain of anti-intellectualism there that I didn't appreciate until I got there, because it is such a reputable institution, or was at the time. I was one of these overachieving high school students with a ton of AP tests. So when I got there, I made the grave mistake of skipping all the first year plebe classes and jumping right into class with the upperclassmen. So here I was, this upstart plebe who's supposed to be dirt and doing push-ups, thinking she's better than everyone else, sitting in like the senior honors history seminar on like military arts, and like, who the heck is this lady? And so I had a TAC officer on my butt all the time, like, why aren't you helping your fellow students pass their physics class? And like, I don't know, I'm busy studying while they're playing Quake and taking naps. I don't know. So like, it wasn't a great cultural fit, and I wasn't sure I wanted to leave. And I made this deal with myself. And I was very full of pride back then. It's like, West Point is hard, and I don't want anyone, including myself and my mother, thinking I quit because it was too hard. So this was my deal. I'm allowed to leave if I get my gold star, which is top 5%, and I get into an Ivy League school. And I did. I got into Penn, and then I left. And so did, I think this speaks a lot to military culture, and it's a combination of women, that every single woman in my class who was like sort of at the top of their class, you know, took the AP test or got into the advanced classes, we all left. All of us. All 10 of us. So yeah, and then I went to Penn, and I was totally lost at Penn. I didn't know what I wanted to do. I was exhausted. I was burnt out. I played a lot of video games. I played a lot of poker. Drank maybe a little too much. I didn't really know what I wanted to do. So I picked a major that seemed really broad and capacious, which was PPE, philosophy, politics, and economics. And that's before it turned into like a department of behavioral economics. So it was a lot of political theory, a lot of like, I got exposure to some heterodox economic theories, and it was really, really interesting. And I finally learned to love it, but I didn't know how to turn that into a career. My boyfriend at the time said, well, we should go to law school, because he was in the same major. And I was like, all right, that sounds fine. It's better than being an administrative assistant somewhere. And so like 2 days or a day before the deadline, we both applied to William & Mary because he really liked it. And I was like, fine. I remember I filled out the application in pencil, you know, took the LSAT late. I studied a little bit for it, but not a ton. Anyway, but we got in. And so they threw me some money. So I was like, all right, fine. I like school. Let's do more school. It's not going to. So yeah, so I thought I went to William & Mary, which is in Williamsburg, Virginia, which is actually a really interesting town. It's like half tourism, or no, a third tourism, a third Navy, because the Atlantic Fleet's stationed there, and a third like conservative rich people with sailboats, right? and then there's this little liberal arts campus there, you know, full of like rabble-rousing students, you know, so it's a very interesting neighborhood. Anyway, so I went in thinking, oh, I'm going to do public service law or constitutional law or something very theoretical. But it was boring to me. And instead, now this is the twists and turns of life, or another twist and turn. It was boring to me, but what was fascinating to me was the business law classes. Not because I ever dreamed of being a corporate lawyer. I was like, I've come from this left-wing family. I'm a Democrat, registered Democrat. I've always registered Democrat. In fact, I'm more Democrat than most Democrats. But like, there's something about learning how the sausage was made that fascinated me. And so I ended up taking all of these business law classes, you know, from BizOrgs to M&A and securities. I even took some regulation classes, food and drug law. I remember I was like all about how Orrin Hatch was like destroying America by allowing people to sell us supplements without any regulation and stuff like that.
Still a problem, by the way.
Yeah, right. Yeah. So I had fun, and I wasn't thinking about my career at all until I had to. So 3L year, like crap, I need an actual job. And it turns out when you take a bunch of business law classes, the only interviews you get are with like corporate law firms. Go figure. And I knew I wanted to go back home near my family, which they're a little northwest of Philadelphia. None of the Philly firms would hear from me. And I guess it's because, well, Philadelphia and the surrounding areas has a ton of excellent law schools. Why are they going to hire someone from William & Mary? But Delaware was interested. And so I ended up in a mid-sized, like kind of boutique firm in Wilmington, Delaware. Another William & Mary alum, I will appreciate him for the rest of my life, pulled my resume out of the stack and gave me an interview. And there I was. And I say boutique, not that it was a tiny firm, but like a lot of Delaware firms there, their concentration was in corporate and bankruptcy. So they had a tiny little family law practice, but mostly for those families If there's a divorce or a death or something, there are business affairs to wind up or deal with or split. So, and that's how I got my foot in the door with corporate derivative litigation. And back then, and this is 2005, 2006-ish, what they used to do to get the litigators' experience litigating before there was real money on the line is throw you into a couple of bankruptcy cases. So, you would go to bankruptcy court and argue a $1 million claim, which is small beans for some people. Yeah, we were first got litigation chops, showing up, arguing creditors' claims in bankruptcy court and various adversary proceedings. And the stakes were relatively small, so they felt safe letting us cut our teeth that way. And so most of my litigation experience is Court of Chancery in Delaware, some bankruptcy hearings in the bankruptcy district of Delaware. And the Superior Court of Delaware, which handles the big commercial cases that don't have equity jurisdiction. So think gigantic contracts. Yeah.
So it's good that the firm had a way to get you actually into court early.
Yes. Yeah. It was wonderful. Because a lot of the other time, back then we didn't have like outsourced doc reviewers and algorithms and stuff. So a lot of the other time, if you were just a litigation associate, you'd be reading emails for like privilege. It could get very boring, right? So I was glad to have the opportunity to dip into bankruptcy every once in a while.
Yeah, I remember getting to spend 3 days in a storeroom in Birmingham, Alabama, going through like 25 years of an insurance company's history and somehow survived it.
I don't know how. Only someone young and desperate to please bosses, I guess, can pretend they're excited to do that. But
yeah, I didn't pretend to be excited. So while we're in Delaware, recently there was a proposed amendment to the Delaware corporate general law. Or did I do that backwards or forwards?
Far be it for me to correct you, Neil.
Go ahead.
Delaware General Corporation Law, or DGCL, or just say Title VIII or Delaware law. It doesn't matter.
That's why I worked for a New York chartered company, so I didn't have to be able to say all this stuff correct.
Well, this is about Delaware lawyers' job security. I need to say the words, to make us seem really unique and special, and like there's, a lot of secrets that we guard and special knowledge that we cultivate that only we can distribute. So, I have to keep that mystique up.
But what is the motivation behind it? I mean, we've been talking about the race to the bottom since I was in law school, and probably before that, although that goes way back in history. Is that what this is about? Is who benefits from these proposed changes?
I have the superficial answer is to benefit controlling shareholders and a very specific kind of controlling shareholder from a specific kind of company, which are those rock star CEOs of Silicon Valley. They are like the Mark Zuckerbergs, of course, the Elon Musks of the world. Not only have an executive officer hat on, like their CEO, and they're often on the board of directors too, and they often have quite a significant equity stake in the companies. And as a result, they would get themselves into a lot of trouble with conflict of interest transactions, standing on both sides of the deal. Relatively recently, over the past decade and a half or so, the Court of Chancery have been cracking down on these controlling shareholder transactions, meaning someone like Elon Musk would only own like 20% of Tesla. So he's not on paper a controlling shareholder. He doesn't have enough votes to control the outcome of an election, but has enough influence and connections. It's particularly relevant in Silicon Valley companies where the networks are, for lack of a better word, very incestuous. Like every banker knows every CEO, which knows every venture capitalist. They all know each other, and they all share the same professor at Stanford or something. And so there's like these very interconnected boards and management staff. And then when they're combined with this like rock star CEO, someone who's only a 20% shareholder on paper becomes the dominant personality in a company. They become a controller. And because the Court of Chancery deemed someone like Elon Musk to be a controller, they get slapped with fiduciary duties, which opens them up to liability. So what this legislation does, it makes it a lot more difficult for the courts to say someone like Mark Zuckerberg or Elon Musk or Jeff Bezos or some other controlling shareholder is a controlling shareholder. So it would allow them to escape liability. And why? I mean, I'm not up on local Delaware politics anymore, but Elon Musk, after he lost that case about his pay package, which, you know, the Chancellor McCormick, who is wonderful and such a great role model, especially for me and other women interested in corporate litigation. I mean, okay, throwback, digression. When I was practicing, which was, you know, circa 2005 to 2011, there were no women on Chancery. Now there are several, and one is the actual chancellor, which is like the chief justice of the Court of Chancery. So this is wonderful to see, just to see that. So I'm like, okay. So anyways, she said the Tesla had to rescind Elon Musk's pay package. Elon Musk gets angry about that and reincorporates in Texas. And so they're afraid that the Delaware General Assembly is going to be afraid that they're going to lose that business. And so it's a matter of like fiscal policy to do this for them.
But if you make it so much harder to litigate successfully, then the Delaware lawyers that were your colleagues are not going to have the same opportunities that they once had. Is that fair?
Absolutely fair. And you're exactly right. And it's quite ironic because Delaware corporate lawyers are very accustomed to speaking in terms of short-term incentives, short-term profits versus long-term profits, and how directors have the discretion under the business judgment rule to pick either should they want. But the Delaware General Assembly does not right now. Short-term, sure, they'll save some franchise taxes. Long-term, does this state even have an economy if there isn't any litigation to support all of the lawyers, you know, which is Delaware is a tiny state. There's 3 counties, right? It's got like 3 industries: law, chickens, and credit cards. And like, that's it, right? So yeah, it seems very counterproductive. And also this legislation was introduced in a bizarre way. Usually when a new law is proposed, it is because there was a big case that was controversial. Plaintiff side of the bar, the defendant's side of the bar think about it a lot, deeply. They collaborate. It takes a very, very long time. And then there's sort of a bipartisan consensus that forms before it's introduced to the Delaware General Assembly. That didn't happen this time. It was very rushed and very quick and just slapped on the agenda last minute. So this gets me to the deeper point about this proposed amendment is that I would like to make is that I see it in line with all of the other changes that are happening right now in the federal government. Just like, I don't want to say Delaware is ignoring the rule of law by any means, but they are ignoring and crushing norms that have served them very, very well over time. Crushing bipartisan norms that have served them and deliberative norms that have served them very well over the time in order to make happy someone like Elon Musk, who claims to speak on behalf of humanity, you know, who is the savior of the world or savior of free speech, you know, and so there are some very uncomfortable resonances between that situation in Delaware and what's happening at the federal level today.
So you transitioned into the federal, so let's just go right there, because next week you're going to be moderating a panel at the 34th Annual Corporate Law Center Symposium that is, 8 months ago I chose the topic as administrative law, thinking, well, we've got some recent interesting decisions to discuss and maybe it'll still be timely then. For anyone listening, we're going to take her pen away from her now if you're hearing the clicking. And instead, we're finding ourselves, a week out from the symposium with a pile of executive orders about administrative law,
Mhm.
and we're in a bit of a quandary as to how much of that should we be worrying about. As I was saying to one of our colleagues, Dean Tomaine, we could set our hair on fire for 6 hours and run around waving executive orders. We could talk about these cases as if all these executive orders haven't happened because they don't actually have force of law, or at least they say they don't.
Right.
So how do you find the middle ground between the, let's run around with our hair on fire yelling about the rule of law, or should we just be doing that?
All right. I'm hesitating because I'm trying to decide how full-throated I want to be about this. And I'm going to put my social scientist hat on for a second. So part of my bio that I didn't get to talk too long about was a transition away from my practice in Delaware to PhD school in political theory. And then I finally became a law professor, which is the best job ever. Anyway, but
we were going to go back to that, but
I'm political theory. Yeah, but so if I put my social scientist hat on, all right, when you think of democratic backsliding or a shift to authoritarianism, and I'm begging the question there, and I have to justify that that's where we are. We always thought that it couldn't happen here. Why can't it happen here? Well, the separation of powers. There's federalism, state versus federal government. There is the 3 branches of government, plus this independent 4th branch that is administrative agencies, a lot of them independent. 2, America is just too big. It is too hard to get all of those people in lockstep with the authoritarian program, and it is too hard for authoritarians to control that many people. 3, civil society. If you have a robust civil society full of strong, robust institutions like universities, like churches, like labor unions, like corporations, even the most ideologically driven authoritarian government won't be able to control everything. There will be too much pushback. All right, so where are we now? Can it happen here? 1, separation of powers. Well, we have the Republican Party with a trifecta, with Doge and Russell Vought and the OMB, a combination with all the executive orders, quickly hollowing out the administration. Okay, what about 2? America is just too big. Well, social media brought us a lot closer together, and now connected as we are technologically, it is really easy for a couple of people to flip a couple of switches and screw with all of our lives. Okay, what about 3? Civil society, labor unions. Weak and getting weaker, although we have seen some positive signs. Churches, we see a lot of our organized religious institutions on board with the Republican agenda. Not all of them, by no means all of them, but many of them.
And
universities.
Their influence is dwindling as the
Yes.
population becomes less and less religious.
Yeah, more and more secular, right.
Yeah.
Universities, it's a whole nother can of worms, but we're struggling with the threat of getting our funding yanked unless we get with the program. Okay. And then combination with the social isolation that has been ongoing for years, that sort of Robert Putnam bowling alone thesis, COVID, there's not in the last Trump administration, we had a lot of corporations pushing back. This is not the case anymore. A lot of those superstar CEOs that I talked about are lined up at his inauguration. So I'm afraid. And so what can we do? I mean, other than show up and protest, which, authoritarians are scared of, they can't lie about their support if there's 1 million people on the street saying otherwise. But other than that, what can you do? We got to build back the civil society. Go to your bowling league, make a bowling league, is start going to church again, right? Join your union if you're lucky enough to have a union. Try to create a union. I don't know. Or just work on, developing networks amongst your friends and family. All right. So, this is leading me to my second point, because this started with a question of why do we care about judicial doctrine? So the answer to that is we shouldn't, because that's not the problem right now, right? The problem is regime change. And when it comes to judicial doctrines surrounding administration, what I think the problem is the problem is not that we won't have the right policies, or we should write better policies, or we should write better laws, or we should, or whether executive orders are law or not, what is law anymore? And I can talk about that. I think the problem we're going to face is one of state capacity. With the hollowing out of administration, with firing all the people, cutting all of the funding, no matter what law we come up with, no matter what policy our best policy wonks come up with, won't mean bupkis if you can't follow through. And that seems to be the trajectory that we're on, is this hollowing out of fundamental state capacity. That said, the interaction of the legal doctrine as articulated by the Supreme Court and these executive orders where they converge, where they collide, is still important because it helps us understand the ideology underpinning this, ongoing attempt at regime change. And so maybe we can find ways to push it back against it with that understanding. But that's just my social scientist. I have my social scientist hat on right there.
Okay, so assuming that we decide that we are still going to talk about judicial doctrine.
Yes, absolutely.
I guess, when we talk about capacity, and I think a lot of us right now are asking too much of the courts.
Yes.
Right? Or, and it's very easy also to complain about Congress, right? That Congress can step in and do its job here. But there are also places where I look at, I've been writing a paper with Professor Mank on the good neighbor provision of the Clean Air Act, which if everyone wants to take a nap right now, it's a good time. They can pick up the podcast again in 5 minutes. But there's a part of that provision that says that it applies where one state makes a significant contribution to another state, pollution. And significant contribution are the words Congress came up with. And obviously that's not a numerical standard. And leaves open the argument that somebody's got to interpret this standard.
Right.
Before Loper Bright, under Chevron, it was, does the agency have a reasonable interpretation of significant contribution? Now it will be, what does an Article III judge think of it? Unless Congress comes back and says, no, actually, we think 70 parts per billion is the right number for 8-hour ground level ozone. And, find me a congressman that can tell you what 70 parts per billion of 8-hour ground level ozone means. And I'll buy you a Skyline lunch.
Right.
Just to show we are in Cincinnati. So when I put all that together, I'm like, okay, who can we look to say solve this problem when we have set up a whole system around the idea that Congress isn't capable of doing that level of detail, and there isn't really any guidance for the court, no matter what Chief Justice Roberts' opinion says about how good courts are at interpreting law. I just take this one example of what does significant contribution mean, and I'm like, okay, so who's going to fix it if not those people who are, in your words, being hollowed out of the system?
Yeah. When I think about this question and questions like it, and it's an excellent question, I just, it makes me angry because all of the great thinkers about politics and law and the meaning of politics and law, none of them ever mentioned administration. Go back to ancient Greece, the birthplace of democracy. And you got your Plato's, you got your Aristotle's, talking about the birth and death and corruption of republics, and Plato thinking about the ideal republic, right? And no one mentions how the republic is actually supposed to get stuff done. Now, I have a friend and colleague, he's a political theorist in South Carolina, Doug Thompson, and he told me once, yeah, well, the reason why the Greeks didn't talk about administration is because all of that stuff was done by their slaves. And so why would they bother talking about it? But it was incredibly important. And every state that did anything has to have an administration to carry out its policy. Now, in America, one of the things that we did new, I think, with administration is that we very consciously tried to build administrative bodies that built in democratic feedback. Like, here is a policy-making or lawmaking body, but we're not ruled by a king, right? This administration is not just following marching orders from their sovereign. Their primary duty is to the public in a country committed to democracy. So we had democratic feedback mechanisms built into the bureaucracy itself, like noticing comment, right? So it was a wonderful, certainly it has a lot of flaws. But it was a wonderful thing. And I don't know how we do anything about anything without it. I mean, the reason why we have a bureaucracy is because no other body was suited to solving problems like the ones you just described. The courts could not do it. They cannot hear that many lawsuits. They don't have the expertise to handle that many lawsuits without themselves hiring basically an army of bureaucrats who are experts to tell the judge what the law, what it should be. Right? It's physically impossible, just like it's physically impossible for any state worth its name to get anything done. So the more problems society gets, the more bureaucratic it gets. Why did we have agencies to begin with? Why did we get our ICC? Our first administrative agency in the late 1900s. It's because railroads were screwing over farmers and price gouging them. And the only thing that could handle it was an administrative agency. There was no other solution. We don't have the imagination, I guess, to come up with another one. I certainly don't. Maybe there'll be some algorithm someday that can fix it for us. But then you have to trust the person wielding the algorithm, I guess, which doesn't sound particularly democratic.
Unless the artificial general intelligence figures it out on its own.
Yeah, well, don't go Curtis Yarvin on me, no.
No, I'm just, that was actually intended as a joke for people that took it seriously. Don't.
No, I know you're not serious.
But then when you look at, I think the criticism of the administrative state is that it is not responsive, not effective. I mean, one of my favorite books, and it probably says something deeply wrong about me, that it's one of my favorite books, was called Implementation. I don't know if you know the book. It was written in 1972 by Aaron Wildovsky, who, I was doing poli-sci 30 years before you were, and I didn't get the PhD. But it was a study of a jobs program, a federal jobs program in Oakland, California, where they were trying to put X million dollars, I don't remember off the top of my head how much it was, but it wasn't a small amount of money, into a jobs program to create local jobs. And at the end of 5 years, what they had accomplished was to pay about a couple $1 million worth of architecture bills, and really nothing else. And it wasn't because there was fraud. It wasn't because there weren't well-meaning people involved. Everyone was trying very hard, but implementation was much harder than the people that were trying to do it thought it would be. And so I kind of, when I look back at that and go, wow, more than 50 years on, I don't think we've really fix those problems. And I think that there is an issue with how effective administrative agencies are. And instead of addressing what would make them more effective, we're just taking a literal chainsaw to them.
Right. Right. So when usually when I'm presented with, all right, this situation is not ideal, my follow-up question is always compared to what alternative? So one alternative that's commonly offered is privatization. But in fact, our federal government is largely already privatized with the inordinate amount, like a huge amount of federal contracting that we do. And even if it wasn't contracted out by the federal government, but simply a service provided by the free market, I mean, we all have fond memories of, Comcast and Spectrum, right? The pinnacles of, customer service and efficiency there. So efficient compared to what? Second, it's like sometimes the slowness of bureaucracy is, I don't want to say, a feature, not a bug. But when you have any decision-making body that is, at least on paper, ostensibly committed to deliberative decision-making, that tries to solicit the input from various different interest groups who have conflicting interests, the process is going to be slow, and sometimes the outcome is going to be irrational. You can get in a bureaucracy that's a lot more efficient, that's run, say, more like an army, and that can be very effective, particularly during emergencies, like during COVID. I'll put an asterisk there, or during the financial crisis in 2009. Like, those bureaucrats literally call, like, when you read about even the vocabulary they use to describe themselves, like, we're at war, we're generals, like, this is, have to do shock treatment, like they're shock troops. You can get very efficient very quick if you govern things like a military, like an autocracy. So that's a trade-off. And reasonable minds can disagree, and maybe it should be context sensitive. Like, maybe in your case, a jobs program is really important because if people don't have jobs, they starve. And so maybe that part of the bureaucracy should have been run more like the military, I don't know.
Yeah, I think, I think it is a common criticism, and I think sometimes we as lawyers don't help the situation by, trying to stay out of trouble and keep our agency, our department, our little group out of trouble. You can run into, I think the technical term is fussy readings of statutes
yes.
and regulations, where, it will drive the average person crazy.
Yes.
And then we also, I think, sometimes are over-reliant on what we think technology will do. I had a situation last year where my son, and if you're listening, Sam, I'm sorry, I'm going to talk about the fact that you were unemployed for a time, but my son went and applied for unemployment insurance. He was living in DC at the time. And he did everything right, got a notification that he did everything right, and yet the payments didn't start. So I would tag along with him as his lawyer, and we'd go to the unemployment office, and they explained that, well, we had a new software system come in, and nobody quite knows why it's not processing correctly. And essentially their answer was, maybe in a couple of weeks, check back, and the system will have healed itself and figured out your problem. And this went on for like 6 weeks. And, and thank goodness he had, a lawyer father who wasn't taking no for an answer, because they would have just kept pushing him away, saying, don't worry. But there was some high-level bureaucrat that had been sold on that software program as the solution to all their problems, instead of a whole new set of problems. And the end of the story was, finally, somebody got tired enough of seeing us that they hand-entered all the information, and he got his benefits.
Well, congratulations to you for being an excellent advocate.
Or a pain in the butt, or
which is excellent advocacy.
Advocacy at times, right?
All right. So I have a couple.
There wasn't a question there. But,
no, but I have a couple of questions for you. I don't know if they're real or rhetorical, but when I see, all right, I guess two. So when I hear stories like that, one follow-up question I would ask is, was it a personnel problem? Did they not have enough people, right, to learn the software, to implement the software, to train everyone up on the software? So I mean, the United States could have been funding its agencies more robustly. And that helps.
So let me talk to that one. I think one of the things that you see
Mhm.
in any organization,
Mhm.
and I see it here, having joined the
Mhm.
University of Cincinnati staff,
Mhm.
I've got Concur, I've got Canvas, I've got a
Yeah.
whole bunch of, probably 12 different software
Yeah.
programs I have to interact with to do my job. And most of the training was, you'll figure it out.
Yes. Yeah. We could have spent, an additional X amount of dollars a year on someone whose job it was to make sure that we knew the technology to do our jobs. Instead, they've outsourced it all to us to figure out individually, which, we pay for, through the lack of free time we have, I guess, because we're spending 20 hours trying to figure out what the hell Concur is and what it does and why it always gives me an error message every time I click something. But yeah.
Because you have to allocate, and then you have to allocate after you allocate it.
Yeah.
And when you've allocated
Yeah.
twice, then you might have to allocate a third time.
Yeah.
That's and there's usually one person in the building.
Yeah.
I mean, here it's Jamie,
Mhm.
that you run upstairs and say, Jamie, what am I doing wrong?
Yeah.
And I think, to the other point about personnel is this wasn't a bunch of lazy bureaucrats.
No.
Every time we would show up in the office,
Mhm.
people who really cared about what they were doing, who were working there for
Mhm.
all the right reasons, who had nothing, no way were they trying to figure out a way to make it hard for my son to get
Yeah.
the benefits that, he'd paid for
Mhm.
in his taxes. They just couldn't make it happen.
Mhm.
And once they eventually did make it happen, it wouldn't have been possible then for them to do it for everyone that had the same problem.
Right.
To go back and just,
Yeah.
hard code it
Mhm.
to make it work.
And this is not to say that the problem is always just understaffing. I mean, you can engage in a kind of management science. And like when you go to business school and you learn management, you're learning how to be effective and manage people effectively. But part of effectively also means, profit maximization, cost cutting, running things as leanly as possible. But it doesn't have to be that. So you can, instead of trying to maximize two things, like a for-profit business, like lowering costs, maximizing profits, while also being effective, you can just focus on maximizing effectiveness and implement that kind of management science into the government. But especially since the 90s, I feel like, the management science in administration is more of the for-profit corporation kind. So you'll see the same kind of problems, when you interact with private organizations. Like here, well, we're a state school, but some of the private schools I've went to, had the same problem.
Believe me, I've worked for lots of companies where the number of software programs I had to interact with was mind-boggling. And, in a few of those companies, I got to be in a position where I could say no. But, sometimes like when I worked for Avnet, we were on a massive spree of acquisitions. And every time we would buy another big company, it would come with 25 subsidiaries that we didn't need anymore. It's very easy to create a company. It's very hard to make one go away, especially if you're doing it in Finland or Hungary or wherever, And so we had to manage all of these companies, corporate secretarial, and doing it on paper seemed like a vastly, horribly inefficient way to do it. So we went out and got software, and then my poor team spent the next 2 years feeding the data monster. We brought them this thing which we said is going to make their job easier, and instead, several of them quit.
Yeah.
Because their job was they no longer understood it. They didn't understand why the software didn't work. It didn't matter how much training I gave them.
Yeah.
It was just a massively complex problem that the software wasn't really designed for.
And a lot of times you're facing a peg and a poke when you're thinking about, and it's scary. Yeah.
So I think, but you often hear people talk about, running, we should run government like a business, and we elect businessmen from both sides of the aisle, expecting that they're going to go in and take their business acumen into it. And, it's not ineffective, in my opinion, because government is run inefficiently and businesses are run efficiently. It's that both are inefficient in different ways.
Yes. Yeah. And they both have different accountability mechanisms, if you will. So if you're in a business, ultimately, in addition to, or rather in lieu of your shareholders holding you to account, it is the market. Is your business doing well or is it not? But for government, the accountability is political accountability. It's elections. It's being responsive to your constituents and being responsive to Congress and being responsive to the statute you're supposed to be carrying out. And, so therefore you're also accountable to the courts. And you try to mix in profit maximization like that, or cost cutting or efficiencies. Of course you're going to get something irrational. You're trying to please too many masters.
That's probably a good segue into your PhD and dissertation, which you know better than I.
Well, okay. So I wrote about corporations. And when I first walked in the door at Columbia, my soon-to-be dissertation advisor, Jean Cohen, I love you, Jean, she said to me, "You want to study business? What are you doing in political theory?" She's got, she's grew up in Brooklyn her entire life. She's got this delightful accent. "What are you doing here? Why don't you go across the street to the business school?" I said, "Jean, let me explain this to you, right? In that the only vocabulary we have to talk about relationships within the corporation is economics, law and economics. What's efficient? Is this a principal agency problem? That whole." For those who are inside this baseball, Jensen and Meckling, Alcuin and Demsetz, that kind of stuff. Or the doctrine, just pure doctrinal, theory, I guess, or not even theory, just the doctrine. And I found that deeply unsatisfying. And there were two cases, actually, that solidified my need to get out and start thinking about corporations a bit differently. One was the Massey Energy case. So Massey Energy is a coal mining company in West Virginia, and for years and years and years and years have been public knowledge, broadly known, violating safety regulations. For years and years and years, the shareholders had elected the leadership that engaged in all these safety violations. And what do you know? There's a huge explosion in the Big Branch mine and 41 people died. So, as is the case with a lot of cases that go through Delaware, every firm in Wilmington gets a piece of the action. So everyone is involved in the massive energy litigation. And what happens is the shareholders sue management for breaching their fiduciary duties by ignoring all these safety regulations, leading to the explosion. So the same shareholders who elected these people made money by electing them because the share price went up, the company was making more profits, now get a second bite of the apple after, the inevitable happens. And I took this really personally. My mother's family were coal miners in West Virginia. And so I got angry. I'm like, why is there no vocabulary to talk about this power dynamic? There is none. So I'll stop there. So I got angry, and frustrated. And also that the financial crisis was going on, and I'm starting to educate myself about that. And I finally started reading, economic history, political history, trying to figure out this wackiness that is the macro financial international world of, and I remember someone at work who was a Cambridge economist said, it's all because, we left Bretton Woods, and I'm like, what is going on? So this curiosity is developing because I'm learning just how ignorant I am with this growing conviction that the law, as the law that governs the most powerful entities who have the most impact on people's lives, there's no way to talk about that in power. And so I'm like, I'm going to go learn about power, economic power. So that's how I ended up in PhD school. I applied to 50 different places. I had no idea if anyone would let me in. I think I got lucky. I don't know, maybe they were short that year. And honestly, it was the idea at that point, because you work really, really hard, like the billable hours. I mean, it's hard. It's hard work. So the idea of taking 6 to 8 years off to like read books for a living sounded like heaven to me. So, I mean, I guess I lit my practice career on fire, threw it in the dumpster, and started a new life. So, and then, fortunately, after I, defended my dissertation, was lucky enough to get it. By the way, for those of you on the job market right now, I sent out 208 applications before I got my first teaching job as a mere contingent postdoctoral fellow at UVA. And then I sent out another 150 applications before I got my first full-time tenure track job at Dayton. So I know the pain. So.
Yeah, and I think it's, we just recorded yesterday for the extern class a conversation about grit versus quit, which, Grit is the famous book by Angela Duckworth that says that, in fact, she did the study at West Point, to bring it a little bit full circle, that those who succeed are the ones who persevere.
Yeah.
And then I love, as a counterpoint, a book by Annie Duke, who is also an organizational psychologist, but was also most famous as a professional poker player, who wrote a book called Quit, which is where people stick at things too long. And my favorite quote from that book is that quitting on time often feels like quitting too early. And you almost said it when you talked about leaving the practice of law and lighting it on fire. You had to feel at that point, I'll put words in your mouth, like, what am I doing here?
Yeah.
Why am I blowing this up?
Right. Well, a life lesson I learned, having been a West Point quitter, if you will, is that whatever organization or industry, whatever you're in right now, it's going to feel like you are some kind of failure or some kind of traitor if you choose to leave. And what I learned, so, I left West Point and I felt guilty. Like, maybe I wasn't hard enough, or maybe I wasn't strong enough, or maybe I was, too liberal or too female, or I just couldn't cut it for whatever reason. And, there's definitely a culture that encourages that kind of thinking. That's everywhere. I felt the same pressures when I left private practice. I felt the same pressures in PhD school when I decided to go on the law school market instead of the political theory, political science department market. This, you're always going to feel like you're betraying your tribe in some way. So the end of the day, it's so contrived, but do what makes you happy. Do what gets your juices flowing. Like, I like law school because you get to think your way through problems and make rational sense of the world, but also have your hand on the grass outside. I'll quote Marx, not because I am a communist or anything, but, the point of philosophy is to change the world. And I loved that crunchy, practical focus of law school. Now, a lot of people think that law school has a kind of split personality. It doesn't know if it's a liberal arts school or like vo-tech for desk jockeys, right? And this shows up amongst the professors too. Like, some people are all about doctrine and you shouldn't be writing papers unless it's doctrine. And then some professors are more like me, who are a lot more theoretical and ivory tower and egghead. I think, and law school should pick. I don't think it should ever pick. Because the doctrinal people, the real-life vo-tech people, remind the eggheads like me that, by the way, the point is to make a difference in the world, to stay in the real life. We're not philosophers in that sense. We're not in Plato's cave or whatever. But at the same time, the eggheads like me can make sure the doctrinal people are thinking more deeply about, the causes of the doctrine as it shows up, the social, whether the economic causes, the cultural causes, the social pressures that cause things to look like the way they are, instead of pretending the entire legal landscape can be explained through some, vacuum-packed legal science that has no bearing on actual human beings and how they live their lives. So I think we work really well together, honestly.
Yeah, I think that I would add a third category, the practitioners like me who are masquerading as if we're here at the law school for we are here hoping that people actually learn something and that we can get jobs. And
Neil, you're the only member of our faculty who encapsulates both these things. You are a practitioner, right, who is working with students, and getting them into the corporate law clinic and practicing. Well, you're also writing papers, right? You're also thinking your way through it, right? And you're giving this guidance to your students. Like, the law school should be people like you, honestly, who can do both.
Okay, well, we're going to stop the episode. It doesn't get any better than that. Question that we came up with was an outgrowth of something I became fascinated with while I was working in South Africa, although working became an overstatement when state capture allowed the meat and dairy industry to basically put my little plant-based food company on the shelf for long enough to kill it. And so I became fascinated with the shareholder versus stakeholder debate, and concluded at the end of writing a 50-page paper that it was an argument that we keep having without any concrete result from that argument. You can watch the Business Roundtable go, we're about stakeholders, we're about shareholders, we're about stakeholders again. And I think that what they really mean is we're about stakeholders when it serves the shareholders.
Yeah.
And then you put the business judgment rule on top of all of that, and there is no real accountability mechanism for the answer to that question anyway.
Right.
And that's that debate. Then when I saw Corner Post, which opened up the statute of limitations under the APA to challenge a regulation when you suffered the injury instead of when the agency put out the regulation, left me wondering, okay, does a company manager have a fiduciary duty to pursue getting rid of every bothersome regulation now that Corner Post has given them that opportunity? And then, in the last 2 weeks, we've had an executive order come out directing all of the agencies to say whether any of their regulations fall into one of 7 buckets, some of which are things that I think push shareholder value down.
Right.
Although they never use that actual word.
Right.
So that's how I kind of said, all right, this is one of the things we need to talk about this symposium on administrative law. That's where my thinking came from to why this is a topic that I've settled you in a panel of 4 experts with.
Well, it's a very impressive panel. I'm so excited to meet them all in person. And it's a really important question. And not just to shoehorn, corporate law into this this really urgent topic, but because corporations are the primary targets and also a really important co-author, if you will, of regulations. I mean, when they just notice and comment, who do you think is filling out those comments, right? Who is lobbying the congressmen to, to direct the agency to do X, Y, Z, right? And agencies themselves will reach out to corporations, the regulated industries, to see, what they think and get their feedback. So corporations are really intimate actors when it comes, involved intimately with regulation. So it's an important topic. And all right, so when it comes to fiduciary duties, at least in Delaware and under the MBCA, you have a standard of conduct and a standard of liability, and they are not the same thing. So do directors have a fiduciary duty under Delaware law to challenge a regulation? As a matter of liability, I would say no, because under the law, you do not have a duty to maximize shareholder value unless the company is up on the auction block. I mean, this is Revlon. But as a standard of conduct, non-enforceable by shareholder derivative litigation, well, directors and other fiduciaries have a duty to manage the corporation in the best interest of the company in good faith, right? And keep themselves reasonably informed. You can make an argument that indeed it is a fiduciary duty to challenge those regulations that are not in the best interests of your company. But of course, the follow-up is like, well, what's the corporation's best interests? And for me, I understand this as a quintessentially political question. What is the corporation and what's in its interests is akin to asking, what is America and what is its best interests? Even if we're looking at a citizenry of just shareholders, they're so diverse. Even in just in terms of money, some people want to make money now. Some people want more steady returns and have money later, right? But that constituency can be those stakeholders you talked about. And arguably treating your stakeholders well is also in the shareholders' best interest in the long run. But as John Maynard Keynes says, in the long run, we're all dead, so it doesn't matter now. And this is a quintessentially political question. And so corporate law gives us a political solution, elections. If you don't agree about the decisions your directors are making about what's in the corporation's best interest, vote in new ones. Of course, only shareholders can vote. Stakeholders can't. So we kind of got like in ancient Greece, they had things called medics. We said they're sort of like citizens, but they're sort of not because they're not allowed to be involved in the government. So we have people, or in the United States, even today, a lot of folks can't vote. Children can't vote. If you're mentally incompetent, you can't vote. A lot of ex-cons can't vote, right? So like how, so there's that kind of disfigurement, right? And also corporate democracy, even amongst shareholders, is known to me kind of a joke. Like if you believe that democracy requires a viable opposition party, corporations do not have viable opposition parties. In fact, it makes it big news when they do. And it's usually because there's a takeover of some kind in the works, right? So it has a very backward kind of, not even a competitive authoritarian kind of democracy. So I think corporate law is right in that these questions are political questions that should have political solutions, but it's wrong because the democracy that corporations have isn't any kind of democracy. But that being said, and this goes back to what we were talking about earlier about agency efficiency. You make your corporations more democratic, they'll be less efficient. So that's an intractable trade-off. I know what Stalin and Lenin chose. They, top-down command economy. China too, in some respects, right? So, I don't know. I guess America has sort of inadvertently come up with a compromise between efficiency and democracy within its corporations. And I don't know if it's perfect, but we're America, so that's what we do. We try things, and it usually it's not perfect, but it's okay for a while.
That's probably a pretty good place to end here at the 1 hour mark.
All right.
Unless there's something that you wanted to cover that I left out. I'm still a good enough litigator to ask what should have I asked you that I didn't ask you at the end of the deposition, even though this has not been a deposition. Right?
Well, no, I'm good. Thank you so much for having me. I won't take advantage of this captured audience anymore. So.
Thank you so much. I really enjoyed the conversation. Now you have to do this annually.
Okay.
Yeah, the week before the symposium, you're going to be the Corporate Law Lab guest.
All right, fabulous.
All right, sounds good. Thank you.
Thanks, Neil.